Now, the Council for the Advancement of the South African Constitution has been admitted as a friend of the court in the upcoming IEC's appeal against the Electoral Court order, which allowed former President Jacob Zuma to remain on the uMkhonto Sizwe Party list. The Electoral Court recently upheld Zuma's appeal against the disqualification of his candidacy. That's in terms of Section 47(1)(e). Now, the Specialist Court, in its reasoning, found that the Commission erred when it applied that section to former President, as Zuma's 15-month sentence was not appealable. Now, in 2021, Zuma was found guilty of contempt of court and sentenced to 15 months imprisonment. The IEC is now turned to the Concourt in a hearing scheduled for the 10th of May 2024 for finality on this matter, which will inform the current and future elections. Now, CASIC Joy says its role as the friend of the court is to provide submissions that focus on the separation of powers and principle and the nature of the president's power to remit sentences. Let's get a more detailed explanation there. We're now joined by the Executive Secretary of the Council for the Advancement of the South African Constitution, Lawson Naidoo. A very good evening to you. Thank you so much for your time. I mean, this is a matter that you have been admitted as a friend of the court, and we know that the IEC clearly feels disgruntled with the arguments used by the MK Party to overturn this decision. Perhaps expand a little bit on your role in this matter.
Good evening, uMkhonto. Thank you very much. CASIC's primary interest in this is that we believe that this case raises fundamental constitutional issues around the interpretation of Section 47(1)(e) of the Constitution, as well as the fundamental principle of the separation of powers. So there'll be two arguments that we will seek to place before the court to assist the court in its understanding of the legal issues at play here. Firstly, on the issue of the non-appealability of the conviction and sentence. And now we know full well that the matter was dealt with by the Constitutional Court, who deemed Mr. Zuma's conduct in not attending the State Capture Commission of Inquiry to be in contempt of its own order, convicted him of contempt of court and imposed a sentence of 15 months imprisonment. That was then, because it was the highest court in the land, it was obviously not appealable, and we believe that the Electoral Court has got it wrong in ruling that the provision in Section 47(1)(e) does not apply because the sentence was not appealable. It's a rare instance where the Constitutional Court will hear such a matter as a court of first and last instance, but it is something clearly anticipated in our legal and constitutional framework. Mm-hmm. But our main argument that we will present to the court is around the issue of the separation of powers, and that a sentence is something that is imposed by the judicial arm of the state, by the courts, and that once that sentence has been imposed, the responsibility then exists on government or the executive to manage that in terms of being responsible for correctional facilities, as well as of remission of sentences, of parole, and the presidential prerogative of issuing a pardon. And we believe that the Electoral Court got this wrong in its reasoning that was published on Friday.
How should it have been approached to begin with, in your view?
Well, in the case of in the issue of the sentence, we believe that the separation of powers clearly would require that the sentence imposed by the court must be respected at all times, that the effect of an executive decision, whether by a parole board or by the president in this case, for the purposes of reducing overcrowding in prison, simply means that the term of the sentence is reduced by executive decision, but it has no impact on the initial sentence. Mm-hmm. And particularly in the context of Section 47 of the Constitution, we believe that the Constitution rightly places that responsibility in terms of the length of service to exhibit and demonstrate its dismay with the kind of conduct that would demand a sentence of more than 12 months. That should be a judicial function and should not be subject to political interference. If the issue of a remission of sentence is going to impact on the eligibility someone to stand as a candidate for election to the National Assembly, it means that political factors can come into play, and that certainly cannot have been the intention of our constitutional drafters. So we believe that the two have to be clearly separated. We will bring to the attention of the court numerous cases from foreign jurisdictions, and many electoral systems have similar provisions to ours, where people who have been sentenced for a significant period of time in prison are prevented from standing for public office, and we will draw on the jurisprudence from those other cases in other countries to demonstrate how that has been interpreted, and our constitutional design requires a similar interpretation of the provisions here.
We know, Lawson, that at this stage, as you and I speak, it's not clear whether or not the appeal will be finalized before elections on the 29th of May. How do you think the question of former President Jacob Zuma's eligibility to stand or otherwise affect the election outcome? More so because what could have happened here is a person who is not qualified being allowed to contest.
Yeah, well, so firstly, we know that the case is going to be heard on the 10th of May, and we certainly hope that the Constitutional Court will at least provide an order and a decision ahead of the elections on the 29th of May. I think that's important, even if they may provide their reasons at a later stage. But I think it's important that the court reaches a decision ahead of the election, so that as voters go to vote on the 29th of May, they are very clear as to who the candidates are that are contesting this election. Now, Mr. Zuma, in this instance, is a candidate of the uMkhonto political party. That party will remain on the ballot paper, and those voters who wish to vote for them will have the option of doing so. It will just be a question of the Constitutional Court determining whether Mr. Zuma's name is on the candidate list that has been submitted to the IEC, or whether his name will be removed from that list.
Depending on which way this matter sways, what sort of precedent do you think that it could essentially set, and of course affecting or not affecting the tone of the elections?
Well, I think it will provide legal clarity for all of us, for South Africans in general, and I suppose for the IEC in particular, as to the interpretation of Section 47(1)(e) of the Constitution regarding people who have been sentenced for a period of more than 12 months, and you know, their eligibility to hold public office. That will clarify that issue, and also you know, the issue of whether a sentence imposed by the Constitutional Court, is also falls within the ambit of that section. So I think it's important for the purposes of that clarity, for the purposes of clarifying the powers and responsibilities of the Electoral Commission in terms of making that determination as an electoral management body, which obviously is subject to challenge in the courts, but in the first place they had the responsibility to decide the issue. But ultimately I hope that whichever way the Constitutional Court determines this matter, we all accept the outcome and ensure that the elections that we hold next month are indeed free and fair, as they have been conducted by the IEC over the last 30 years.
Yeah, absolutely. Thank you very much. Let's perhaps leave it there for now. Executive Secretary of the Council for the Advancement of the South African Constitution, Lawson Naidoo, giving us that explanation around the reasons behind CASEC being friends of the court.